All right, good morning, good afternoon, good evening, wonderful people of freedom all over the world. Wherever you are joining us from today, you're highly welcome to this wonderful YouTube platform that gives you only quality news and information on all the activities happening in Biafran land. Please subscribe to this channel and make sure you turn on your notifications so that you will be notified whenever we drop our spanking news. Now, without wasting much of your time, make we go straight to the news because the news update is actually a very bubbling one at that matter. Biafrans all over the world are being optimistic currently, concerning the update coming from Nnamdi Kanu's court hearing. As we all know, today is a trial of Nnamdi Kanu. Let me remind you that today is the 26th, being Monday, and it is the trial of Nnamdi Kanu. That is why the whole of Biafran land is in total shutdown. When I mean total shutdown, Biafran land is in standstill currently. First of all, the Prime Minister, Simon Ekpa, announced the total shutdown of Biafran land. Not just because of the continuous Monday sit at home, but extra, to show solidarity for the leader, Nnamdi Kanu. Now, without wasting much of your time, we are giving you updates, direct from the court, from the Federal High Court in Abuja. And without wasting much of your time, tight security as Nnamdi Kanu trials resumed. The news reads in detail. There is heavy security presence at the Federal High Court in Abuja, where the federal government is set to resume the trial of the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu. All routes lead to the court, which is beside headquarters of the Federal Ministry of Justice, have been condoned off by armed security operatives. Only those whose names were on a list by operatives of the Department of State Services DSS were granted access to the court premises. The Supreme Court had on December 15, 2023 granted the federal government the nod to proceed with the trial of the indigenous people of Biafran leader, who is facing charges bordering on terrorism and treasonable felony. The Apex Court vacated an order of the Court of Appeal that not only quashed the charge but equally ordered the release of the defendant. The indigenous people of Biafran leader Nnamdi Kanu, who was first arrested by security agents in Lagos on October 14, 2015, has been in detention since June 29, 2021. And we want to clarify as Biafran that Nnamdi was not arrested, but he was adopted by the Nigerian and terrorist government. We continue with the news. Trial Justice Binta Nyako on April 25th, 2017 granted him bail on health grounds after he had spent about 18 months in detention. Upon the perfection of the bail condition, he was on April 28, 2017 released from the Kuje prison. However, midway into the trial, the indigenous people of Biafran leader escaped from the country after soldiers invaded his country home at Afaruku Ibeku in Umuahia State, Abia State, an operation that led to the death of some of his followers, including his father and his mother. Nnamdi Kanu was later abducted in Kenya on June 19, 2021, and extraordinarily renditioned back to the country by security agents on June 27, 2021. Following the development, the trial The trial court on June 29, 2021 remanded him in custody of the Department of State Services (DSS), where he was remained till date. However, trial justice Nyako Binta on April 8, 2022 struck out 8 out of the 15-count charge at federal government 15-count charge that federal government against Nnamdi Kanu on the premise that they lacked substance. In the said counts, federal government had alleged that Kanu, through his media broadcast, incited members of the public to not only stage a violent revolution, but to attack police officers and also destroy public facilities in Lagos State. Federal government alleged that he had, in his broadcast that was received and held in Nigeria, issued a deadly threat that anyone who flouted his sit-at-home order should write his or her will. He told the court that as a result of the threat, banks, schools, markets, shopping malls, and fuel stations domiciled in the eastern state of Nigeria were not opened for businesses. Citizens and vehicular movements in the eastern state of Nigeria were grounded also. It further alleged that Nnamdi Kanu had on diverse days between 2018 and 2021 made a broadcast received and held in Nigeria inciting members of the public to hunt and kill Nigerian security personnel and their families, thereby committing an offense punishable under Section 12H of the Terrorism Prevention Amendment Act 2013. We continue with the news. More so, federal government also alleged that Nnamdi Kanu directed members of the indigenous people of Biafra to manufacture bombs. He told the court that the defendant had, between March and April 2015, imported into Nigeria and kept in Ubuli Suzo in Ihiala local government area of Anambra State, a radio transmitter known as Tram 50L concealed in a container of used household items, which he allegedly declared as used household items, and thereby committed an offense contrary to Section 47(2)(a) of Criminal Code Act, Cap C 45 Laws of the Federation of Nigeria 2004. Notwithstanding the pending allegation, the Abuja Division of the Court of Appeal on October 13, 2022 ordered Kanu's immediate release from detention. In a unanimous detention by a 3-member panel, the appellate court quashed the entire charge against the detained leader of the indigenous people of Biafra before the High Court. The court said it was satisfied that federal government flagrantly violated all known laws when it forcefully rendered the Nnamdi Kanu from Kenya to the country for the continuation of his trial. It held that such arbitrary use of power by the Nigerian government divested the trial court of jurisdiction to further try the appellate court. Dissatisfied with the decision, federal government took the matter before the Supreme Court, even as it persuaded the appellate court to suspend the execution of the judgment pending the determination of its appeal. Likewise, Nnamdi Kanu, through his team of lawyers, led by Professor Mike Ozekhome, Senior Advocate of Nigeria, and Mr. Ifeanyi Ejiofor, also approached the Apex Court to query the legal property of the order and stayed the execution of the verdict of the appellate court. In his judgment, the Apex Court faulted the appellate court's verdict, saying it was based on sentiment. In the late judgment that was prepared by Justice Gaba Mohammed but read by Justice Emmanuel Egim, the Apex Court held that the Court of Appeal did not anchor its decision on any extant law in the country, but on international statutes that Nigeria is signatory to. As far as Nigeria is concerned, he said, the lower court did not cite any Nigerian authority. The Apex Court noted, even as it slammed federal government for acting irresponsible when it bypassed the law to bring Kanu back to the country for the continuation of his trial. Be that as it may, what is the position of the Nigerian law, where an accused is saying an illegality has been committed against me? It is like saying that the evidence should not be admitted because it was illegally obtained. Our law is that, notwithstanding the procedure, it is still a valid evidence before the court. If the police arrest a defendant, torture them, and illegally obtain evidence, does it divert the trial of its jurisdiction? The court queried. It held that the remedy open for Kanu was for him to institute a civil proceeding against federal government. That is the position of the Nigerian law. The Apex Court held, adding that the judgment of the appellate court, through noble, still remains within the realm of sentiments, they said. Insisting that judgment in such a case must be based on express legislation, the Supreme Court said it found no reason to align itself with the position of the appellate court. There is no legislation in Nigeria that says the trial court will no longer have jurisdictions where prosecution does anything illegal against a person standing trial. If prosecution destroys someone's home in search of evidence, that will not stop the trial but will raise a cause of action. We decline to go to the Court of Appeal inasmuch as we strongly condemn what the prosecution did. The court went further to say, Nigeria must be concerned about its image, both locally and internationally. If a person is standing trial, why must you invade his home? That is totally irresponsible, the Apex Court also added. It held that federal government ought to have approached the trial court if it felt that Nnamdi Kanu breached his bail conditions. Besides, it held that the High Court acted wrongly when it revoked the initial bail it granted to Kanu, saying the action was totally unfair since he took a flight to save his life. Nigeria barely recovered from the case of Umaru Dikko, and we should not repeat it. The Apex Court warned as it upheld federal government's appeal marked SC/CR/1361/2021 and dismissed Kanu's cross appeal marked CS/CR/394/2022. It ordered Nnamdi Kanu to go back and defend himself on the 7-count charge that is pending against him. Kanu reportedly sacked his legal team after the judgment. And that is that on the update, concerning Nnamdi Kanu's case. It has actually been a roller coaster, of a case. A lot has really happened, during this period of Nnamdi Kanu's trial. So many things has been exposed. So many people also has been exposed. So many lapses has been exposed also in the Nigerian judiciary, where they have actually contradicted their laws. And that is one thing about the Nigerian government. and the way that they have always operated in their illegality to handle situations. You cannot eat your cake and have it. That is one thing you should know. You know, one thing that the Nigerian government has constantly been doing, like I will always say, is that they have been, circumlocuting around the whole case. Habaragelo, habaragala. They are running to and fro without any conclusive, conclusive measure in that case. Nnamdi Kanu case would have been a simple case of, discharge and acquit him just like you did and stand on your grounds. As court of competent jurisdiction, stand on your ground as the judiciary. Yet, you allow them, the executive arms of government, to actually, intervene. You allow them, the president, to intervene, thereby causing your decision to be biased. Now, people have actually seen that you're not that you're incompetent to handle, a common case of an innocent man who was, first of all, who was abducted by the Nigerian government and illegally renditioned back, to the country. You did all your illegality with a neighboring country, and yet you're still defending yourself of every illegality. It's actually crazy. But this is Nigeria, where anything can actually go. So far it is illegality, so far it is corruption, anything can go. But we are here to give you the update concerning Nnamdi Kanu's case, because a lot is going to go down, today. So all you have to do is to stay glued on this channel to get all the information of the update that will be happening today on the court hearing of Nnamdi Kanu. We hope that it will be a successful one, and we are optimistic that finally that the court will do the right thing by giving freedom to Nnamdi Kanu. Please make sure you're sharing this video wherever you are. Continue to share this video to as many groups, to as many platforms as possible, because our people need to be informed. They need to know what is happening to their leader. They need to know every detail on what is happening on Nnamdi Kanu's case. And we on this channel, we are here to give you that information as it is hot, as it happen for Abuja, as it happen. Please subscribe and continue to choose this news platform for more updated news and information. God bless you once again for choosing this wonderful YouTube channel for your news and updates.